instrument which provides for the making, interpretation, and implementation of law. Under Proviso 2 to the unamended article, the power of amendment could be increased. There are no express or implied limitations on the power of amendment. There is no distinction between essential and non-essential features of the key Constitution to raise any impediment to the exercise of the power of amendment. The preamble does not operate as a limitation on the Hay-1 power of amendment. Lex Amendment is a form of growth of the Constitution, and the term for amendment connotes definite and formal processes of constitutional change. These processes of change are the evolution of the Constitution. The force of tradition and custom and judicial interpretation may all affect the organic structure of the state. The object of amendment is to see that the Constitution is preserved. Rebellion or revolution is an illegal channel of giving expression to change. The consent of the governed is that each generation has a right to establish its own law. The people expressed in the preamble gave the Constitution, including the power to amend the Constitution, to the bodies mentioned in Article 368. These bodies represent the people. If a constitution provides the method of amendment, that method alone is one eagle. Any method other than the method provided in Article 368, as for example, convening constituent assembly or referendum, would be revolutionary. Article 368 restricts only the procedure or the manner and form required for amendment, but not the kind or character of the amendment that may be made, the deliberative and restrictive process. And one procedure, ensure a change in the institution in an orderly fashion, one in order to give expression to social necessity and to give permanence to the Constitution, 392, XPRE. See on amendment of this Constitution has a clear substantive meaning 1 and T. Context of a written Constitution, and it means that any art of Constitution can be amended by changing the Saurabh variation, add 1 T on, or repeal. The words for amend MC and T of this Constitution may be initiated, and the words 1 the Constitution shall stand amended in AC accordance with the terms of the bill in Article 368 indicate that the word 26 Supreme Court Reports 1973 SUP-VSCR amendment is used in an unambiguous and clear manner. The word 1 amend is used in a constitution to denote any kind of change. The various amendments which have already been made to the Constitution indicate that provisions have been added, varied, or repealed. The meaning and scope out the amending power J in the object and necessity for amendment 10. A written Constitution I for changing the Constitution in an orderly manner and for making changes in the fundamental law or organic lay v to change the fundamental or basic principles in the Constitution. The background in which ARI TICLC 368 was enacted by the Constituent Assembly has an important aspect on the meaning and scope of the power of amendment. The Constituent Assembly made no distinction between essential and non-essential features. No one in the Constituent Assembly said that fundamental rights could not be amended, even in the debate on the Constitution, First Amendment Act. No one doubted the power of Parliament to amend fundamental rights. Proceedings in the Constituent Assembly show that the whole Constitution was taken in broad perspective, and the amendments suggested fell under 3 categories: providing for simple majority, or 2/3 majority, or 2/3 majority, and ratification by the states. These different procedures were thought of to avoid rigidity. The conclusion is that the meaning of the word amendment is wide and not restricted. If there are no limitations on the power, it is the whole power, 391, 396, 397, 398. There are no inherent or implied limitations on the amending power. The theory of inherent and implied limitations on the amending PO is based on the assumption of a narrow and restricted meaning of the word amendment to suggest that the basic features or the essential features of the democratic republican character of the Constitution cannot be damaged and destroyed. This court in Berubari case F 1963 SCR 250 said that the preamble has never been regarded as the source of any substantive power because such powers are expressly granted in the body of the Constitution. This court said, 11. What is true about powers is equally true about prohibitions and limitations. The petitioner's contention that the preamble is not a part of the Constitution, and so being unalterable, other provisions which gave effect to the preamble cannot be amended, has no force. The contention that the preamble is not a part of the Constitution, is nullified by the petitioner's reference and reliance on the preamble as the source of all inherent limitations. The preamble in a constitution refers to the frame of the constitution,